Good afternoon, everyone. My name is Salvatore Di Costanzo, and I'm an elder law attorney here in Westchester County. I practice in Yorktown Heights and Rye, and we're bringing to you these informational short pieces, no more than half of an hour, each week to try to educate you on some of the estate planning topics that are important to you and everyone else out there. And like I always do every week, I hope everybody that's watching is doing well, is healthy and safe. And I want to thank all of the first responders, all of the doctors and nurses and staff in the hospitals and the supermarkets, everybody that's helping us today get through this virus. Extremely, extremely important people. And I extend my gratitude to you, and I hope everybody watching would do the same. Thank you for helping us get through this crisis. We've been speaking about a myriad of topics. Just for purposes of review and at the risk of being repetitive, I've discussed how we can attend to your estate planning remotely these days. Governor Cuomo has signed some executive orders allowing us to do so. So we're up and running with remote estate planning, which has actually become quite convenient for a lot of people. We're hoping that when this pandemic is over, maybe they'll change the laws in New York State to allow us to continue to do these types of remote estate planning sessions, because they've been working out for a lot of people. By the way, if you have been watching us and you like this, please like us on Facebook. Visit my website at Plan Today for Tomorrow for more information. But we encourage you to share this with your friends and family. And so we also talked about different types of planning techniques or planning scenarios for minor children, setting up trust, wills versus revocable trust, and things like that. Today, what I thought we would do is talk about common mistakes that I've seen in my practice from an elder law estate planning perspective. And there are a lot of mistakes out there, and I can't spend the amount of time that I would want to spend to discuss everything that I see, but I thought I'd give you some flavor for some of the things that people are doing wrong, or some oversights that I see, to just try to help you prepare to do your estate planning, and if you've already done your estate planning, to maybe take a second look at it and make sure that you're not missing anything. One of the things that I see on a regular basis before, and this is really unrelated to drafting documents, when people do their estate planning, very little attention is paid to beneficiary designations. And I thought I'd start with this because this is important, and it's not even something that I necessarily can help with. But I often see people that have drafted wills or they've drafted revocable trust, and when they pass and I'm presented with their estate, so many assets that could have had a beneficiary designation on them, like a life insurance policy or an IRA, are missing those designations, which results in having to probate a will usually. We talked a little bit about that last time, but let's remind everybody what probate means. What does that mean? The probate process is the process of taking your last will and testament after your death to the court and going through a systematic process where we prove the validity of your last will and testament. It culminates with the appointment of an executor. So, interestingly enough, your last will and testament prior to your death actually has no legal significance. It's actually not an operative instrument until you pass, and then it becomes operative where it's presented to the courts. You can change it any time prior to your death. We try to avoid probate in certain situations because it could be a cumbersome process, it could be a lengthy process, but you have to go through probate if you have a will, but only for certain types of assets, and that's where these beneficiary designations come back into play. If you have an asset with a beneficiary designation, like a life insurance policy or an IRA, those items don't need to be probated. They automatically pass to the beneficiary. But your house, for example, let's say you're single or widowed and you have a house. In order for us to sell that house after your death or to transfer it to the kids, we have to probate. We've got to get the executor in a position to be appointed by the court so that way they have the authority to then sign a deed and enter into the transaction to sell your house. So we know we have to probate for certain things, but we don't want to make the probate process unduly burdensome, or if there was no plan to probate because you had a revocable trust or possibly a Medicaid trust to protect your house if you got sick someday. We don't want to end up in a probate because some life insurance policy or IRA did not have a beneficiary designation on it. So I encourage you to check your beneficiary designations and make sure that, number one, you have them, and number two, that they're the right people. If you've been divorced, make sure you've changed your beneficiary designation from your ex-spouse to whoever it is now, your kids or your new spouse. Upon death, upon divorce or annulment, your beneficiary designations are no longer effective as to that spouse that you were divorced from. But it usually leaves a void that you need to fix, right? So even though that beneficiary designation is no longer valid as to that spouse, you may have no beneficiary designation, so you want to get your kids in there. So beneficiary designations are really important. Another oversight that I see on a regular basis is where younger families draft wills and they have minor children. And they don't leave the assets to the minor children in some form of a trust. You don't want to end up in a situation where you leave assets to a minor child outright. It creates a complexity of issues. It's extremely burdensome. It's going to be very difficult for the child to get to those assets without legal intervention. So the proper way of leaving assets to minor children is to draft a trust to leave those assets in trust, so that way we stay away from the courts. And in doing so, it's important to take a look at your beneficiary designations again, because if you draft a last will and testament and you set up trust for your children, you've got to go and change your beneficiary designations. Even if you have beneficiary designations in place, they might say my spouse, and if my spouse predeceases, my children. But your children are minors, and your estate plan is setting up trust for your children. So how do we get that insurance to go into the trust under your will? We have to customize beneficiary designation forms. So you've got to take that extra step, and this is why it's important to work with an elder law attorney, somebody that's seasoned in this area, not a general practitioner, because we've got to take that beneficiary designation, craft our own beneficiary form that says, my spouse is the primary beneficiary. If my spouse predeceases, the trustee of the trust that I created for my children becomes the beneficiary. So we don't want the children to be outright beneficiaries. That's a really big deal, and it's often overlooked by the people that have drafted their plans and financial planners. So this is really good information for you to hopefully take notes on and check your estate plan. Another oversight I see is people not planning well in advance for long-term care. I see people coming in often that say, Sal, I want to get my affairs in order. And I'll say, what does that mean to you? And they say, well, Sal, I need a will. And obviously maybe a power of attorney and a healthcare proxy. And I'll say, what happens if you get sick someday? And there's like a blank stare usually. And I say to them, I say, can we agree that we might get sick someday? And the answer is obviously yes. Everybody can agree that we might get sick someday. And then I said, if we get sick, is it possible that you can end up in a nursing home or needing care at home? And clearly the answer is yes to those questions. And then I say to them, well, how are you going to pay for it? And there's, if you haven't thought about this, it's a little scary, because there's very few ways to pay for your long-term care. You can pay for it yourself, which is extremely expensive. If you have long-term care insurance, that works, but a lot of people don't have long-term care insurance today. A lot of people can't get it, right? If you have Medicaid, Medicaid pays for, at most, 100 days in a nursing home. So that's not a great option. And then the fourth option is Medicaid. So you've got private, long-term care insurance, Medicare, and Medicaid. Private, long-term care insurance, and Medicare are not really great options. I shouldn't say that. Long-term care insurance could be a good option if you have it and if you've got the right policy. But private and Medicare are not good options, and most people don't have long-term care insurance. So you're left with Medicaid as being your option for long-term care. And a lot of people are doing Medicaid planning, and a lot of people are applying for Medicaid. Notwithstanding the fact that the rules are becoming more and more stringent, that's even more a reason why you should get to doing your planning. But a lot of people go into an attorney's office and they just draft a will. And if you just have a will, you haven't done anything to try to protect your assets if you've got to apply for Medicaid someday. Because the Medicaid program requires that you don't really have much in the way of assets. So another common mistake is people don't attend to this because they think that they have assets and there's nothing you can do about it. But that's not true. If you sit down with us, if you sit down with an elder law attorney, we can set up trust. We can set up a Medicaid trust. We can do other planning techniques that move your assets around, whether it's to your kids or to a trust or to your spouse, that in essence take the assets out of your name for Medicaid purposes so that way we can get the care that you need. So there were two oversights in that topic. One is falling short of doing the proper planning. We don't want you to just have a will. A will is really not enough. You know, I joke around with people all the time. I say a will takes effect when you die. I said dying's not the problem. What the problem is what I call the space between. I wrote an article about this. It's probably on my website. You can find it. The space between is a period from now until death. And you got to plan for incapacity, disability, all the different things that affect you but don't kill you. And if you don't have the right planning in place, you could deplete your resources, which in essence takes assets out of circulation for your family, away from your children, away from your grandchildren, and that's not the name of the game. As an elder law attorney, we try to focus not only on a last will and testament and other documents like that, but the Medicaid trust, which is an irrevocable trust, which protects your assets. So that's another oversight. Some people have revocable trust. We talked about revocable trust. Revocable trust avoid probate. And sometimes there's good reason to avoid probate. For instance, if you have property outside of New York State, if you have disabled beneficiaries or minor children where you're setting up trust, we really don't want to be involved with the courts when you're doing things like that. But in order for a revocable trust to work, you need to put your assets into the revocable trust. So if I were to set up a revocable trust for you and your only asset was a Fidelity brokerage account, once we're done setting up the revocable trust, you then have to go to Fidelity and change the account so that way you, as the trustee of your revocable trust, own the Fidelity account. Now that Fidelity account has been placed into your trust. The reason why that's important is because in order to avoid probate, the asset needs to be in the trust, otherwise the revocable trust doesn't work. So the oversight that I see on a very regular basis, unfortunately, it's sad to say, people set up these revocable trusts all the time, and they don't even know why. Because it's not a one-size-fits-all, but unfortunately, you might have been to a seminar, your friend might have done it, and so you did it. And you sign these documents, you set up the trust, and you don't do anything after that. You don't put your assets into the trust. Well, when you die, to the extent that you have assets that need to be probated, they're going to be probated. They're not part of the trust. So you defeated the entire reason or purpose as to why you drafted a revocable trust. If you don't put your assets into the revocable trust, it was a complete waste of money, and it's actually more complicated because a lot of times you do have some assets in the revocable trust, but not all of your assets, and so we need to administer the revocable trust, and we need to probate your estate, which is burdensome to everyone. So if you have a revocable trust, make sure you review your assets. Make sure that your assets, if necessary, were transferred to this trust. And if you're contemplating a revocable trust, remember that the assets have to go into the revocable trust. You hear me talking often about powers of attorney. Very, very important document, the power of attorney. If it's not drafted properly, it's deficient or insufficient, and it's not worth the paper that it's written on. So another common mistake I see is people taking powers of attorneys off the internet or getting them drafted by a local general practitioner, and they have not been modified to include all the special provisions that we see as elder law attorneys on a regular basis. It's insufficient today to just go and just say, I need a will, I need a power of attorney, I need a healthcare proxy. The days are over where you could just work with anybody on these documents. If you work with the wrong person, it's more than just making a mistake. The documents that you have could be useless. You know, that's a big problem in today's day and age. You know, so we want you to know that drafting a power of attorney is not a simple task. It's an extremely important document, but it's got to be done the right way. So I'm always being presented, by example, children come and sit with me, and their parents might be in a nursing home, or they might need home care. And we need to move the assets out of the parents' names. Maybe we need to move the assets from one parent to the other. Maybe we're looking to move the assets to the children or to a trust, whatever the planning might be. And it's all because we're probably trying to apply for Medicaid to cover the cost of care. So they present me with the parents' planning, and I see the power of attorney, but the power of attorney is a basic power of attorney that has not been altered, has not been modified. And then I have to tell the children, guys, I can't do the planning that I'm contemplating unless we go to court and commence a guardianship proceeding. A guardianship proceeding is the proceeding that allows the court to appoint somebody to control your financial affairs. And that could all be avoided with a properly drafted power of attorney. So just think about how upset those kids are. And not only that, they're now in a situation where they have to privately pay for whatever their parents' care is, and it could be for quite a while. That could have been avoided with a properly drafted power of attorney. So the mistake that people are making is they're not taking it seriously, that this is an area of practice that's unique, it's complicated, it's constantly changing. Just a couple of weeks ago, the Medicaid laws changed. And they're going to their friend who's an attorney, or the guy that they knew for many years, or the woman who did their real estate closing, and they're saying, we need a will. Could you draft us a will? And yeah, they'll draft a will, but you're just going to get a basic will. You're going to get basic power of attorney usually. You're not going to be talking about a Medicaid trust to protect your assets. And at the end, you really didn't do your planning the right way. And it's going to come back to haunt your family. Maybe not you, because you won't be in a position to realize it, but it's going to haunt your family. So work with an elder law attorney. These are very common mistakes. You know, some other mistakes that I see are oversights, which are somewhat unrelated to the drafting of documents. You know, it's a good idea to align yourself with people, other professionals that can help you. Not just me. I happen to be an attorney and an accountant. And you'd be surprised how I'm able to help people to do their tax returns, talk to them about tax implications with their trust, or just general tax questions in addition to drafting the documents. But it's also very important to work with a financial advisor, somebody that's competent, that is not out there to just sell things to you, somebody that really understands a little bit of estate planning, because a good deal of financial planning is estate planning. But it's good to have an accountant to do your taxes. I know a lot of people like to do their own taxes, and I'm not saying you can't, but as the years go on, if something happens to you, if you start to lose your senses, you don't want to leave your spouse in a position where they have to struggle and flounder to figure out how to get a tax return done. You know, what papers went into it? Where do I get this? Where do I get that? It's worth it to spend the few $100s that it costs to do a tax return with a professional, to know that your spouse, whether it's your wife or your husband, can just pick up the phone and call that professional and say, hey, I need help with my taxes, or my wife died, and now what? That return has been being done by the same firm, hopefully for some, quite a while, and it's an easy transition, because anytime somebody becomes incapacitated or dies, it's not an easy transition from the life that you once knew to where you are to where you're going to be. So it's good to have a financial advisor that can put your mind at ease to say, don't worry about it. We're going to do this, this, and this, and everything is taken care of. Just worry about your spouse. And an accountant that can worry about your tax returns. And an attorney like myself that can worry about your legal affairs. So a mistake that people make is the do-it-yourself mentality only goes so far. This isn't Home Depot, right? This is serious professional matters. These are serious professional matters that require people to sometimes hold your hand. And it's a mistake to not reach out to those people. But you got to get the right people. I'll be the first one to admit there are a lot of professionals out there that don't fit the characteristics that I'm discussing right now. So hopefully somebody like me can help you find those people. Hopefully I'm the right person, and put that team of individuals around you to make your life, easier. We also work with care managers at a certain point in time. So maybe somebody that's listening to this is already in a situation where maybe their spouse has cognitive impairments. You're at home, everything's still okay. You're taking care of your spouse, but you should really affiliate yourself with a care manager, so that way as things progress, you've got a guiding light. We work with a couple of care managers, but one in particular that really comes in and saves the day for a lot of families that are frazzled and anxious and nervous and upset. It's not every day that somebody knows how to deal with Alzheimer's or dementia, and there are ways to deal with these issues, right? There's a way to speak to people that have Alzheimer's and dementia. There's a way to manage the household affairs. So it's very much worth having that person that you can call and say, hey, this is what's going on today. What should I do? Or have that professional say to you, in 6 months from now, this is what it's going to look like. So you have time to prepare. You have time to get your family prepared for what the future holds in store for you. So as elder law attorneys, we're not just working on your estate planning matters. We're taking a holistic approach. It's a teamwork approach. I can draft documents for you all day long, and I could sit here for another hour and talk to you about mistakes and oversights in drafting documents. The message that we're trying to convey, though, is, number one, to get in here and work with us. But number two, to pay attention to all of these issues that we discussed and work with a team. A team approach to your estate planning, your financial affairs, your health care concerns is really the way to handle your family situation. It's almost like running a business. And the people that I work with who are struggling with that or are anxious, they didn't take the time to plan in advance. That's why my website is called Plan Today for Tomorrow. It's a catchy website, but there's truth to the website. You have to plan today for tomorrow. You can't wait for something to happen. If you wait for something to happen, you may not have all of the vehicles at your disposal. You may not have all the options that we would normally like to give you. And those are the complex situations, and those are the bad stories that you hear out there. Those are the scary stories where you hear people selling their houses to pay for their care, or probate that's been, the will has been contested, and you've got problem after problem after problem. So with that being said, I'm going to end. I don't think there are any questions.
We got a whole bunch of highs.
Oh, hi. Hello, everybody. I hope everybody's doing well. Hi, Lisa.
Diane.
Hi, Diane. I have to name it. Is
no.
this like Mr. Rogers or something?
It's okay.
I hope everybody's doing well. And my website is Plan Today for Tomorrow. Visit it. You can reach me at 914-925-1010. That's the Rye office. And 914-245-2440 is the Yorktown Heights office. And I look forward to working with everybody. Take care.